SJC-11983, Commonwealth v. Sarah C. Ackerman.
Ms. Harrington, good morning. You've been very patient. We're sorry.
Good morning. May it please the court, Andrea Harrington for the appellant, defendant Sarah Ackerman. This morning, initially, I'd like to address the Commonwealth's arguments in regards to SJC Rule 221, and if the appellant has a right under that rule to have this case decided here in this court. And then secondly, I was expecting to get to the merits of the district court judge's determination and the single justice's determination overruling the district court. In regards to Rule 221, the Commonwealth argues that under the rule that this case is not really properly here in this court today. That's not how I read the rule, and that's not how, I don't think that reasoning is consistent with how the court has applied this rule in other cases. The language of the rule says that appellate review under Rule 221 is available only where the single justice denies relief from an interlocutory ruling and does not report the ruling to the full bench. I took the single justice's denial of the defendant's request for a hearing pursuant to his reversal of the trial court as being a denial of interlocutory relief, to which I had a right to appeal that denial to this court. I think it would be astounding for the court to say that under the particular facts of this case, where the defendant, I was the trial attorney, I argued this motion in limine on 4 separate occasions in front of 3 different district court judges who all upheld Judge O'Grady's exclusion of this particular piece of evidence. It would be extraordinary for a single justice to overturn that, and then for this court to say that the defendant doesn't have a right to pursue an appeal in this court.
Well, let's assume you have that right. Let's reach the merits here.
Thank you.
Why is it not within the appropriate role of a hospital when they get a patient in the condition of your client to check to see whether or not the person is under the influence of alcohol, where they may, and indeed I gather in this case did, give the person drugs to alleviate her condition?
Well, what the district court judge relied on in making his determination that he had the discretion to exclude the test results was that the medical records in and of themselves did not explicitly state that the test was done for medical purposes. And he specifically relied on one line in the medical records where the doctor that was treating my client stated, "Oh, I did a CT of the head, the neck, and the abdomen, specifically because," he said exactly, I'll quote what he said, "because of mechanism of injury and her apparent alcohol intoxication, a CT of the head, neck, chest, and abdomen was ordered." That was a very important
But just
factor.
didn't say the blood test was ordered?
He did
Despite
not-
the fact that it was all because of the intoxication that these things were ordered?
He did not specify a reason as to why the blood test was ordered, whereas he did specify a reason as to why these other tests were ordered.
So is it your view that unless the medical records themselves reveal the reason for the test, that it falls outside of our evidentiary rule?
Well, in Judge O'Grady's determination, he didn't just rely on this issue of were these records done for medical purposes. He made that determination within a larger context about the defendant's rights to confront the witnesses against her under the Sixth Amendment and how that's been interpreted in Melendez-Diaz.
But you have to have something that's testimonial. And there's no case that suggests that conversations between doctors and nurses for treatment purposes or sending information to a lab for medical purposes would be testimonial. Here you have, there's not even a case that comes close to suggesting that. Here you have 12 different tests being done, the blood tests being one of them. And in that context, the doctor is, as Chief Justice Gant said, giving pain medication. They have a restless patient. But not only do you have that, you have the doctor on the motion for reconsideration providing an affidavit. And the judge is just wrong. Under 104A and 1101C, preliminary questions of fact upon which admissibility depends can rely on hearsay. In fact, the rules of evidence other than privilege don't apply. So I quite frankly don't understand any argument to support excluding this evidence.
So this court has not specifically looked at the issue of these kind of results of a medical test done at a hospital and how that fits in with Melendez-Diaz. This court has not heard that issue.
To be the equivalent of a substitute for trial testimony. So the doctor has to be deciding, the doctor has to be deciding whether or not the decision to do a blood test would be a substitute for trial testimony under the primary purpose test of Michigan versus Bryant. And we've held that the confrontation clause, the cognate provisions for the confrontation clause under the Declarations of Rights provides no more enhanced constitutional protection.
Well, Your Honor, I'm sorry I can't speak to that particular case, but what I can explain to you the difficulties with my case. And that is in that we have a medical test that was done by somebody, we don't know who, and so the Commonwealth wants to rely on that evidence, but there are no witnesses for the defendant to cross-examine about any aspect of that test whatsoever.
Well, putting aside Commonwealth versus McLaughlin that says that's perfectly fine, putting that aside, that's how it happens almost all the time.
I would like to just address your statement about Commonwealth versus McLaughlin, because in Commonwealth versus McLaughlin, one of the bases for that decision, and I don't think that the judge, that this court needs to overturn any of the appellate court decisions in order to decide for my client. However, I will say that Commonwealth versus McLaughlin is erroneous in that it says that the right to confrontation and the right to compel the attendance of witnesses, it conflates those two things. In Commonwealth versus McLaughlin, the court said, well, the defendant can just summons the witnesses from the hospital and put on evidence if they think that these tests were not done for medical purposes or if they want to question the veracity of the results. That is in direct contravention of Melendez-Diaz.
I agree with that. I
So
agree with that.
we're taking this out of the private search realm, right? Because this was decided under.
Yes.
Okay, so we're going to take that lens off. If you had a substantial bodily injury case, assault and battery substantial bodily injury, and the Commonwealth summons in medical records to show that the alleged victim in the case had a fractured skull, would that be permissible?
I would say my case is different because there were tests.
I guess the first question is that permissible, you think?
Is it permissible to summons
That be
medical
allowed in
records that
the
somebody's...
medical records that someone had a fractured skull?
Um,
And then you can tell
yes,
me why.
I think that would be permissible.
Okay, and why is your
Yes.
case different?
My case is different because there's somebody who did tests and we don't know anything about the tests. Like if we did these tests in a state police crime lab, we would know they didn't use an alcohol swab because the alcohol
guess
swab
in
can...
the-
We would know, I could ask somebody, we would know, did they use a spectrometer and...
Right, in the fractured skull analogy, right? You don't know why you don't have the x-rays in front of you. You'd love to cross-examine the person who took the x-rays and say, what was broken about the skull, right? I mean, a lot of these medical records assume evidence.
Well, I think that there's a particular problem with allowing the results of a medical test into evidence here without the ability of the defendant to cross-examine.
Is that true of all the medical records? tests that are, I'm sorry, all the tests that were done, like the CT scan and all the other records that would have been part of the medical records, is that true? Is that those as well?
Well, we have to weigh the kind of efficiency and reliability of the evidence in light of the defendant's Sixth Amendment rights. So, I mean, the effects of the CT scan, I mean, they're not relevant to my client's case.
But can we
at all.
go to the core issue? You keep on bringing up the confrontation clause.
Yes.
For the confrontation clause to apply, it doesn't apply to non-testimonial hearsay. There has to be, it has to be testimonial. And we have many, many cases, even cases where evidence collection kits are being, information's being taken. Even in that situation where there's already a criminal complaint, where the statements for medical purposes are not considered testimonial. So to get to this confrontation clause issue so that you can call in the person who took the blood test, for instance, you need to have it be testimonial first. And we don't have any case close to this situation being testimonial.
I certainly recognize that, Your Honor, which is why when I argued this case to the trial court, we talked about 233, Section 79, in that, the judge needed to have kind of a belief that the medical records were done for medical purposes so that he would have some faith that they were reliable, but there's still this nagging question about who am I supposed to cross-examine?
So are those two different questions about whether or not the statute was satisfied and whether or not you have a confrontation clause issue? Are those two separate issues?
Well, I think that the trial court has the discretion to admit the medical records if he feels that that admitting those records would be in keeping with their Sixth Amendment rights to confront the witnesses against them.
Okay, thank you.
Thank you.
Ms. Rose,
Good morning, Your Honors. May it please the court?
I thank you for your patience as well.
Thank you. Megan
And
Rose
Mr.
for the
Pans as well.
Megan Rose for the Commonwealth and Assistant District Attorney Joseph Bierpan for the Commonwealth as well. I'll first start out with the merits of this case. I think this case is clear-cut and simple in that defendant was in a motor vehicle crash, a rollover motor vehicle crash. She sustained multiple lacerations on her arms. She was taken to the hospital. She smelled of alcohol. At the hospital at around 7:38, about 6 different tests were ordered at the same time. 2 CT scans, a complete blood count, another blood panel, and an alcohol blood draw. At that time, the doctors were still assessing the defendant's condition. She smelled of alcohol. She was uncooperative. So in order for her to sustain, for them to assess her more, they needed her to cooperate. So she was assessed to be given Ativan. Under the Gonzalez case is on point in this point where they say that it's common sense that a doctor needs to determine whether or how much alcohol an individual has in order to see if certain drugs that the individual is going to be given to assess their medical condition is going to counteract with whatever they have in their system. I think in this case we have exactly that, and the medical records speak for themselves, which under McLaughlin says, and under Russo says that that's apparent, and that's fine. There's been 3 other unpublished appeals court cases that are exactly like this one, Alvarez, Gonzalez, and Lynx, where same situation, motor vehicle crash, defendant is taken to the hospital and blood is drawn.
Are those cases dealing with whether or not there was a search?
No, Your Honor. Those cases are specifically whether the blood draw was done for medical purposes under 233, Section 79.
79 cases.
In all of those cases, there was no individual from the hospital to come in to testify that the records were just admitted.
So that's sort of the question I was asking before. Is that a question of, whether the judge correctly construed the requirements of the statute versus what seems to be the defendant's complaint is that even if that was so, and even if it was otherwise admissible, that there was still a confrontation clause problem.
And I believe that the only issue here is whether the records were done, or the blood draw was done for medical purposes. Confrontation clause shouldn't be an issue, which was decided by Melendez-Diaz, and also Dyer, which is a more recent decision that overruled the Melendez-Diaz decision, that the blood draw is not testimonial. So confrontation is not an issue.
Now, in the cases you described, was there anything in the record which indicated the reason for the test?
No, those three cases, the unpublished three cases were specifically, the records alone spoke to the reason for the blood draw. In those cases, the defendant also had CT scans. The defendant also smelled like alcohol.
Wasn't there evidence in the records of slurred speech, agitation, panic, as well as smell of alcohol? And I thought there's also some mention that the reason she was held for extended observation had to do with intoxication.
In one of the other cases?
No, here.
Here, she was held longer because of the intoxication. The medical records do speak for that. Is that what you're asking, Your Honor?
Yes.
So is it your view that if it's in the medical records, a judge is obligated to infer that it's for medical purposes, even though the judge doesn't know precisely why it was done?
Well, I think here it's a preponderance of the evidence standard, and especially just by the medical records alone, we're above and beyond that. But then we go above and beyond again and get the affidavit in. And once that affidavit is in, it's clear cut that the blood draw was done for medical purposes.
But you need to do better than preponderance. You need to show that the judge was clearly erroneous, I believe, right? In his finding.
Yes, Your Honor, and I think it, based on the case law that we have before us, it was clearly erroneous here.
So what argument is left after the letter from the doctor?
Excuse me?
I don't understand what issue would have been left in the district court. I mean, I understand that you've got the Sheldon case, Commonwealth versus Sheldon, and you've got some discretion infused into the statute. And perhaps if you look at all these 12 tests, maybe the judge was saying, well, you know, I'm really not sure. But then you get Dr. Ratner's affidavit, and what's left to decide?
At that point, there was nothing left to decide. Everything was determined, and it was determined that the blood draw was done. It was good practice in the hospital. The blood draw was done for medical purposes in order to continue to assess her conditions. If there's no further questions, Your Honors, I'll rest in my brief.
Okay, thank you.
Thank you.
Court, all rise.